David, let's jump right in. Just wanted to go quickly into a kind of a short bio and some icebreakers with you. So yeah, and just a really brief 3-4 minute spiel. How'd you get to where you are, and kind of what's your professional journey been to date?
So I'll tell you, I professionally do government contracts, and I have for about 20 plus years. And I don't think anybody sets out to say, oh, I want to be a government contracts lawyer. I started off going to law school thinking I wanted to be either Jack McCoy from Law and Order or Tom Cruise from A Few Good Men. And I didn't know exactly what that job looked like, but I knew that, well, it ended well on most of the episodes, right? And so,
Yeah.
but once I got into law school, I actually found that I really appreciated the administrative law. I appreciated that there is this whole kind of world out there of just these complicated regulations that companies need help navigating. And so my first job out of law school, I was working for a big law firm doing litigation generally, and most of the clients tended to be government contractors. We did a lot of Civil False Claims Act work for them. And so that kind of narrowed me into trying to figure out some of these regulations. How do you interpret these regulations? What's true, what's false, objectively speaking. And then after a while, I just found myself pretty fluent in the FAR. And anytime you are fluent in the FAR, whether you like it or not, you're a government contracts lawyer. And so, but I'll tell you, I like it. And the metaphor I often use is it's a little bit like river rafting. If you've ever been river rafting, you go out on the river and you want white water. That's actually what makes the journey exciting. And the thing that makes that white water are the rocks that are right under the surface. The stuff above the surface is not making the white water. It's the stuff that you can't quite see. And I feel like with federal procurement, that's really what so much of this involves is you've got 53 parts in the FAR, plus you have the cost accounting standards. Even if you're focused right now on FAR Part 19 small businesses, what do you do with some of these other issues? And so there's always something looming a little bit under the surface. And so that means it's a little exciting. And it means that most days when I set out on my job, I'm almost guaranteed white water. In any given day, I do some litigation, whether it's bid protests or False Claims Act, but I would say probably a good 40-50% of my practice right now is client counseling, where people just call me up and they say, Dave, there's a new executive order, there's a new rule that came out, help me navigate this. And I appreciate that because it's fun. It's every day's a little bit interesting, and you never know what you're going to get.
Yeah, absolutely. Yeah, well, thanks for that. We kind of went into a little bit of kind of like your areas of government compliance, which are pretty much all of them. And I just kind of, before we kind of jump into our official topics, what are some of the biggest problems you face in the federal market currently? Kind of, yeah, I'll just leave that as a pretty wide open question.
So I'll tell you, I think I'm trying to decide, do I get into politics or do I, let me, I'll tell you, in my heart, I'm a libertarian. Like, I want to believe that I'm a libertarian. I'm also a market-based capitalist, which is to say, I believe that there are external forces that can get us to a happy place. And I trust that most of the times, if left up to our own devices, we're going to get there. Now, that actually might be naive, but the problem is, I think, with government procurement is it's so hyper-regulated that it's hard to really breathe, really, in some respects. Mm-hmm. And I wish that we could kind of get back more to a principle-based system and less of a rules-based system, because what happens is you have the government that has these important policies that come out. And maybe it's Congress, maybe it's an executive order that drives it. But the minute that becomes important, suddenly it kind of steamrolls through whatever process this procurement, these procurement regulations are designed to do. And so you have issues like, I guess most famously on this over the last couple of years, the big disruptor has been like these anti-Huawei, anti-Chinese telecommunications restrictions that have come in. Mm-hmm. And they just kind of steamroll through everybody's supply chain. And you say, wait, how do I how do I adapt to this? And we can leaving aside the argument as to whether that's good policy or bad policy. I think we can all agree that driving a truck through what I've been doing for 15 or 20 years, and through my supply chain, and leaving me with a whole lot of questions to ask and with not a whole lot of answers, that's just really disruptive. So my biggest gripe, with all due respect, because I realize it's a hard job, is that I think that the federal government, in their zeal to advance a lot of these policies, it's done with just a lot of indifference, or not really caring a whole lot as to what's the actual practical impact on contractors. And the idea that if I'm going to do these things, if I'm going to go through these extra checks and balances through my supply chain, if I'm going to exclude certain vendors and include other vendors, my price is going to go up and my administrative costs are going to go up. To me, that just makes sense. And I wish the government better appreciated that. But it seems to me that they often, in their zeal to be kind of advance the policy that Congress or the president is asking them to advance, it's also with a little bit of a kind of glaring expectation that, wait, you're going to charge, to do that. And so I think that there's a little bit of tension there between, I really take umbrage a little bit when the government kind of expects that all of these extra requirements are just going to be given away, because that's not how businesses work. So I would say that's my biggest frustration there, is this disconnect between advancing important policies and recognizing that there's an administrative cost, and the government doesn't necessarily want to pay or endorse that kind of administrative burden.
Yeah, I couldn't agree more. I mean, and that was a perfect example. The whole covered communications thing, when it came out, government pushes something. And I mean, I've had a lot of interface with GSA contracting officers and specialists and folks in there. And I've had a minor amount of interface with KOs. And most of them are, they're very happy to talk through issues with vendors even before they become an issue, and kind of take in feedback and have town hall meetings and stuff like that. But yeah, I think on the higher up side, at the political level, when legislation is being made, their take on it is they'll all figure it out, and then it kind of just becomes this octopus that grows an arm every second, and it reaches deeper and deeper down the organization, to the point where thousands of sub departments are trying to scramble and figure out, how are we going to reconcile all this new very important kind of high risk legislation that is rolling through us. How are we going to make the trains run on time when we got a big pile of rocks sitting on the track, kind of thing. So yeah, that's great.
Yeah, and I'll tell you, on that point there, again, I'm agnostic on a lot of these policy decisions and stuff.
Yeah.
I recognize that people say a Republican president will do this and a Democratic president will do that. I actually don't care really a whole lot about a lot of those issues, big picture, like I probably do personally, but when you have to deal with that as a practical business matter on that, yeah, there's really a lot of devil in the details. And I'll tell you, my heart really does go out to like these FAR council people and these government, contracting officers who have to deal with and implement this stuff. Because there is a lot of devil in those details, and I appreciate that they are probably that I'm not sure that the training in the government, especially with the newer workforce, is what it used to be. One of the big stories over the last 10 years has been how the government procurement workforce has been aging out and retiring, and do we have the energy to replace it? Do we have the institutional inertia? Do we have the will? But most especially, do we have the training? And unfortunately, I'm not sure, with how complicated federal procurement is, that they have training for everybody to cover everything. So my heart really does go out for a lot of those people that are trying to implement this. But my heart especially goes out to companies, because they're who I usually represent, and they're the problems that I hear as they're trying to work through this. But I will say this. I do appreciate contracting officers when they're willing to sit and talk with me and listen through things. I find, especially, I know we're here to talk about country of origin issues,
Yeah.
but country of origin, buy American, is something I think that is really commonly misunderstood. People think that it means you must buy American, period, full stop, when the reality is there's a little bit more play built into that. And I find that oftentimes industry, who has had to work a little bit more on compliance and
Mhm.
investing time, energy, thinking on what do we do to make sure our certifications are truthful, have spent a little bit more time on it than the contracting officers. And so I appreciate those moments when they're willing to share information and learn from each other, so that they can improve the quality of the application of these regulations that we all have to deal with. So let's just figure out what the most efficient, accurate way to get through it is. And so I appreciate when there can be that kind of cooperative learning between industry and government alike.
Yeah, yeah. And I think in the procurement world, it's among the best. They reach out to industry quite a bit. A lot of really good communication there. But yeah, that was a great intro. Let's jump into the first topic. We're, like you said, country of origin, TAA, buy American. We're going to go really deep into all that today. If a vendor is unsure if a product is TAA compliant, what process should they go through for discovery on that?
Well, I would say there's probably two avenues that I generally recommend to my clients that they explore. The first is vendor certification. If you are unsure, look, I'm not your lawyer, but I'm your friend. Please don't go out like, this is not something where you want to get out ahead of yourself on. This is not something that you guess on. So if you're not sure, like, state that. Say like unsure, or because you don't want to accidentally misrepresent yourself. So I would say in the first place, the first track, if you're not sure, go to the vendor, or go to the manufacturer. That actually might require you to wind back through the vendor to the OEM to, through the line there, but ask them for a certification. Generally speaking, and that certification might be kind of your standard FAR clause certification, although I think generally speaking, that's more than you need. At the end of the day, as long as you get a representation for them as far as what the country of origin is, that's going to do pretty well, especially for TAA compliance. TAA looks just at the end product. It doesn't look at content. And so if you can get a country of origin representation regarding where it's from, then that's good. Now, the important thing is that you can rely on that too, even if it turns out that that's incorrect. If you've gone through the process of being deliberative, asking these questions, getting this information, and it turns out your vendor made a mistake in giving it to you, well, there is case law that actually says it's okay, prime contractor, you relied on this in good faith. You didn't do anything necessarily with intent to defraud the government. So that's a good first step. Now, if you're relying on vendor certifications, though, I caution that you make sure that you refresh those on a semi-regular basis. Whether it's, I think most companies do it annually, and I think that makes sense. But you don't want to fall into the trap of, I get a certification from Josh Inc. 5 years ago, and then little do I realize that 2 years ago you moved your entire manufacturing to China, and I'm continuing to represent this as a US made product.
Yeah.
That can really be dangerous. And so I think there's a good best practice there. In addition to getting the certifications, whatever that looks like, it's some kind of a representation from the vendor or the manufacturer, and then making sure you're refreshing that on a regular basis.
Yeah, definitely. Yeah, go ahead. You were going to.
Okay, so I said kind of two tracks. So yeah. The alternate track, though, this is the one that's a little bit more in depth, and it's kind of a due diligence, if you will, and it may require you asking some questions, and the intensity, the probative nature of these questions, I think, is really going to depend on what it is. So let's say you're getting a product that has been delivered to you, and the box says made in China, but your vendor is representing that it's made in Canada or made in Mexico. I think that's the kind of thing where you need to kind of pause and say to them, hang on here, I need to ask some real questions here. Like, if if they say it's made in Canada and the box says made in Canada, then I think you have no reason really to question that. But if you have questions where the vendor is unable to give you a clear answer, or where the vendor is, you're getting mixed messages in some respects, then I think it is incumbent on these resellers, these people who are selling directly to the government, to make sure that you're asking questions. And sometimes that might involve, asking for clarification. You present pictures, you interview folks. Maybe it actually goes back so far into the line there to figure out what does the manufacturing look like, where are the various steps taking place. Where's the product substantially transformed? Companies, I think, are generally going to resist that, but as part of an audit, as part of a compliance type process, I hope that you have in your standard terms and conditions the flexibility that you can ask these questions. The worst case scenario is that they are delivering a product to you. They've represented that it's TAA compliant, that it's from one of these 120 plus approved designated countries. And then you have reason to doubt it, but you kind of bury your head in the sand. That's the kind of stuff that False Claims Act cases are made of. And that's the kind of thing that usually have some substantial liability associated with it. So I always encourage people, be thoughtful. And if you have questions, ask questions to kind of, resolve those concerns.
Yeah. That's always good advice. I think every business is a snowflake and has their own unique kind of culture and all that stuff. And I'm coming upon 450, 500 clients, and I can definitely say there's a big spectrum of risk, the amount of risk that some are willing to take on. And then on the flip side, the amount of red tape that they're willing to take on and make sure that risk is, not there. And I have, where one company might get a big order and see some signs, okay, maybe it's made in Canada, maybe it's made in China. I'm going to pick Canada because that one puts more cash in my bank account. And then another company will say, well, no, we're going to put this order on hold and let them know we have to investigate. We've seen some, possible hints that the country of origin has changed. So they might lose the sale, but they're going to probably be around a lot longer.
Yeah.
And they might
I'm generally risk averse because look, when it comes on most things, I'm a lawyer, so it's inherent in my profession. But the idea behind making a false statement to the federal government, I think is just a bad idea every day of the week. And so I think any type of compliance process you can build in to make sure that you're not recklessly doing something. Maybe, look, accidents happen, and I get that. And contracting officers, I think, are willing to work with us if there's accidents. But that idea that we kind of are reckless or we just steamroll stuff in the pursuit of the sale, that's really dangerous. And I hope that people are a little bit more thoughtful about it. It's the biggest risk associated with selling to the federal government. They're a great customer until they come after you with their teeth out. And so let's just make sure that we don't give them a reason to come at us with their teeth. Yeah. All right. Well, let's jump into topic number 2. And that topic is substantial transformation. Within, TAA, there's a lot of gray area where it's, where is this product made? It was, there are components from China, Mexico, and Germany. It was assembled partially in India, and then it was shipped to China, and then it was finally assembled, and the software was put into it in Austin, Texas, or something like that. So with all of these, in this really complex supply chain that's, broken right now, but it's there, there are a lot of components, assembly processes, and a lot of things come into play. And substantial transformation first came across my radar maybe a decade ago, and I had to research it, and it was really hard to find information on it back then. I think after about 2 hours of Googling, I found a PDF from Department of Transportation or something. And I think that PDF is still the document that I kind of go to for help. But this is the world that you swim in. You're in there every day. You have cases, you have precedents. So yeah, what if you don't mind giving kind of just
if somebody doesn't really know what substantial transformation is and why it comes about, just a definition that your office that you go by, and then also just some general pointers on somebody that has to navigate that process and they kind of don't know where to start.
Yeah. Well, before I define it, let me take it back a little bit and just lay the groundwork on this. Okay. So generally speaking, when you're selling to the federal government, you have two competing priorities. And these are binary. It is one or the other. Usually it's BAA, the Buy American Act, or the Trade Agreements Act.
Mm.
Okay, they do not exist simultaneously. There is a point where they trip one from the other, and usually that point when it trips one to the other is the dollar threshold of the procurement that the government's conducting. And this dollar threshold fluctuates a little bit. Right now, it's about $182,000 in 2022, and I think that'll change next in, I think, 2024. They update it every 2 years. So if the procurement's less than that, it's more likely that the Buy American Act will apply. If it's more than that, it's more likely that the Trade Agreements Act will apply. Whenever you see, sometimes you see these contracts that have both Buy American Act and Trade Agreements Act clauses in there. The only reason they should exist in the same contract is if you don't know really what the value is. But at the end of the day, if you get the contract and it's covered by one of these free trade agreements and it's over that threshold, you can officially line those out, although your contracting officer probably won't do that because he or she's not comfortable with that. But in the first place, you don't have these two things existing simultaneously. Now, helpfully, GSA on its scheduled contracts has made the executive decision that they're going to assume that their contracts are, generally speaking, going to be valued over $182,000. So you do not find the Buy American Act clauses in GSA schedules. It's usually just the 52-225-5 clause Trade Agreements Act. Okay, so what does the Trade Agreements Act require? It basically says the federal government shall buy products that are substantially transformed that are made in the United States or in one of these 120 plus free trade agreement countries. And a lot of these are who you would normally think of Canada, Mexico, EU. Gosh, we've got Singapore, we've got Japan, Australia. But it also includes a lot of countries that the federal government says, like, we don't want to discriminate against them because they're small countries, and so we'll deal with them. And so it's a lot of African nations, like Mauritania is one of my favorites in there. But there's about 120 countries, in addition to the United States, that if a product is substantially transformed in this location, then it can be delivered to the federal government. If it's not on this list of countries, then the statute says thou shalt not buy, federal government. And generally speaking, what that means is the government pushes that to vendor and says, you vendor, thou shalt not sell. You need to help me, the government customer, be compliant by not selling me these things. And there you go. Importantly, China, India, Brazil, not approved countries here, not designated countries under the Trade Agreements Act. Now, on China, there's an interesting little wrinkle in there. The Hong Kong and Taiwan are approved designated countries. And we can debate the merits of the one China policy, but the truth of the matter is that the United States has separate trade agreements with Hong Kong and with Taiwan. And as long as those agreements are in place, they're going to be approved countries. So China mainland prohibited, Hong Kong, Taiwan, those are acceptable. So it's important to make sure that you know where the country is from. Okay, so then the next question is, where is it substantially transformed? This is what you get to. And so it's the question of, it's really a holistic question because it doesn't look at any one single process step. It doesn't necessarily look at any one single component. It looks at the end product that is being bought, and then it requires you to back that a little bit through its manufacturing process and find out where was this thing where did it go through a meaningful process that was applied to these components or material parts that resulted in an end product with a name, character, and use different from these constituent component parts?
Hmm.
And unfortunately, there's a little bit of alchemy in there, right? Because it's rarely a single question. And so when I help clients, we kind of have to go back through the supply chain and figure out, okay, where did your components come from? What are you doing? Tell me about the steps. How modular is it? You build into sub-assemblies and then you integrate these, and where are these steps taking place, and where's the firmware installed? And, as you alluded to, and each of those things kind of become part of the mosaic picture to kind of assess as to whether or not it is a substantial process or a meaningful process that is occurring to change the nature of this this content. It's
Mhm.
often considered more. The other phrase that you hear kind of in opposition to this is mere assembly, saying substantial transformation is more than just mere assembly. But it's also sometimes hard to know kind of when and where exactly does this happen. Mere assembly, I often think of as kind of the IKEA test, right? Can you have an idiot like me take a box and we just kind of, I don't know, put it together with an Allen wrench over the course of 10 minutes to 3 hours, right? Depending on how complicated that IKEA set is. But the idea where it's not really, it's a simpler process and not really a manufacturing process, or more particularly, it's a simple process and not really a substantial process. And so that's often kind of one of the trigger points as to what comes up with this. I had a client once who reached out to me once, and they sold rebar reinforcing bolts, and it was a bolt, and it had a PVC frame on it, if you will, that you basically screwed on, and then you would stick the piece of rebar up through the PVC, and it would help reinforce some of this flooring. The question, they said, is that, without the bolt, it doesn't do its job. Without the little PVC housing, it can't connect to the rebar. It's no good unless you put it together. I said, what does it look like? And they just took it and screwed it on, and it took all of 15 seconds. And I said, that's mere assembly. I can go out on a limb and say that. And so even though the constituent parts are useless on their own, there needs to be some sort of a meaningful process that gets those together. Mm-hmm. And there you go. That's a lot of words, and I don't know that gets us to a perfect answer, but it does require some kind of a substantial change, not just into the new end product, but also a substantial change to the content or the components themselves.
Yeah. It's definitely very, very complicated, and there's a lot of murky water around, that's whether the kind of the level of complexity that goes into the assembly process is met. I've come into some cases where somebody describes everything to me, and I'm trying to kind of give them some guidance. And that's when I come to you, when I don't have it, when I'm at the end of my rope. But yeah, they describe it to me, and I say, well, it could be considered a little too simple, but somebody from right off the street couldn't come in and do it with 15 minutes of training. So on the other side, does meet some sniff test regarding complexity. So yeah, mere assembly is, it's in the eye of the beholder, really.
Yeah, well, and I'll tell you, that is one of the things that I do. Is often I have clients call me up and they say, David, here's my problem. This is the conclusion that we've reached. Can you be an objective third party and tell us as to whether or not you think this passes the sniff test? And I say to them, yeah, look, this looks good. I've done some research here. There's the U.S. Customs has a lot of decisions that they've issued on these things that help us figure out what are some of the key steps, especially, these get very product specific, but, what is that, yeah, it looks like what you're doing is sufficient. It's good enough here. Or I often say, like, yeah, I don't think so, but maybe if you move this manufacturing step that you're currently doing in, say, Thailand or Malaysia, what if you brought that into Austin, Texas, that I think would probably tip this over. And that seems to be the most important step here. And so I've helped clients both validate or invalidate what they're doing, and then also try to improve the process there so that they can better match the principle here, which is to say supporting trade and manufacturing in the United States or in one of these 120 plus countries.
Yeah, yeah. And then kind of on the flip side is just the cost buildup. So and this has always been my understanding, please correct me, because good chance I'm wrong. But on one hand, there's substantial transformation happening in a country. But on the other, here's an example. So substantial transformation happens on US soil. But if you do a cost buildup, it's 60% Chinese, the components and all anything that goes into it, 60% Chinese and 40% US. So passes the substantial transformation, but on the cost buildup side, doesn't pass as a majority US dollar, cost made product.
Yeah, so that's a relevant inquiry for purposes of the Buy American Act. And it's a hard thing when you find yourself, you're dealing with both regimes. But the wonderful thing about the Trade Agreements Act, the Trade Agreements Act actually doesn't care about cost of components or content or really where it came from. And I put the caveat on there is sometimes the government cares about where it came from for like security reasons and quality reasons.
Right.
But for purposes of the Trade Agreements Act, look, the truth of the matter is I could have 100% Chinese content that I bring into the United States and I substantially transform it in the United States and then deliver that to the government. The government is just fine on that because again, it's that substantial transformation that has taken place. So the kind of relative content requirement, at the end of the day, it's the US based or the free trade agreement country based manufacturing that sanitizes, frankly, all of that content. And so in that respect, the TAA is actually it's an easier administrative structure than the Buy American Act, because I really only have to check one country. And that's my country of final manufacturing. And it is a rare thing where I have to, dig into the supply chain to figure out where these things are from, because usually it doesn't matter. If what I'm doing is bringing everything into the United States and substantially transforming it here, then I'm good. But I'll tell you what, can I give you two examples of real cases?
Yeah, that'd be great.
Yeah. Okay, so there's like two here that I think are good, and the first one is scary and the second one is great if you're a US based manufacturer. So the first one is it's I think it's 2016 from the US Court of International Trade, and it's called Energizer Battery. And what it is Energizer was basically doing an LED flashlight, and they wanted to confirm that this thing was TAA compliant. And what they did is they grew the LED in China. Most of the batteries, most of the content and the materials were Chinese, although in truth they were international. They'd have like the plastic housing, the click on off button, all of those things were sourced internationally, and then they were shipped into the United States. And then here in the United States, they were all put together, washers, screws, nuts, right? All that careful work. And then ultimately it was manufactured. Before, just a bag of parts. Yeah. In the end, a functioning flashlight. None of this you would want to buy individually, but this is exactly what the government wants to buy. And so Energizer's rationale was it's been substantially transformed because it's this manufacturing process in the United States of integrating these 50 or so parts has resulted in a new product with a new name, a new character, new use, new function. And the court ultimately said, no, Energizer, that's not good enough. And there's a couple key things as to why they pushed through on it. One, they actually pointed specifically to the LED and said the LED is Chinese origin. And at the end of the day, a flashlight its key purpose is to emit light. So if the light emitting portion of this was Chinese origin, that hasn't changed when you bring it into the United States. So they actually kind of looked through to what parts gave this thing its essential character. So I said before that generally TAA doesn't care about content. That's mostly true unless like the government or unless customs is trying to like get to the thing that gives this end product its essential character. And so in the case of the LED flashlight, they said the fact that that LED is Chinese origin, we consider to be a little bit important. But the other key part of it too is that they realized, they said, all of these other parts, they're pre-cut, they're pre-shaped. There's nothing unique in America where the battery housing was maybe your base cap and then the sleeve and then the head, right? And all of those, all that you had to do was screw those together, over the course of a few seconds. If they were maybe one piece that had to be cut and then come together or something like that, if there's something more meaningful that was happening to them. But the fact that these pieces, as they were imported, had their assembled intent preset, the court ultimately said, yeah, that you haven't substantially changed these components or these contents. And so at the end of the day, they said to Energizer, no, your flashlight is not TAA compliant because all that you've done is mere assembly. And then not helping this, at the end of the day, it really only took about 7 minutes for a trained technician, but not necessarily like MIT trained, right? So it can just be somebody off the street that has some basic training on how to do this. It didn't require special tools. And so again, all of these things, I said, it's a holistic analysis. The Court of International Trade ultimately said, we don't really view this as a meaningful, substantial process. Yes, it's assembly. And yes, it's maybe more than just 2 or 3 seconds of screwing a thing together, but it's not a substantial enough process that's changing the content into the item that has a new name, new character, new use. So, that's that really shifted the thinking a little bit about what it means to be substantially transformed. Because prior to 2016, most of us subscribed to the idea that, look, that bag of parts is no good. This end item flashlight that's a meaningful process. The Energizer battery decision makes clear that there's more that you have to do there beyond just mere assembly. And that might be reflected in terms of tooling that you use. It might be reflected in time, but most especially the idea that there's some kind of modification or change to the content. And there you go. Thoughts on that, or should I get into number 2?
The only thoughts I have are, that I learned a lot from it. At first, I'm thinking seems like a slam dunk, compliant product. But as you dug in, the LED and the function, it really just was something that configured or made the LED, it would, made it more controlled or controllable. But and so, okay. Yeah. And I think that complexity of the assembly line, who is and what level of education and training is sitting in front of these parts, putting them together, is that, in the tools, that's a thing too.
Right. Now, and I'll tell you, at the end of the day, I actually don't know that like legally that matters a lot, but optically it does. And to the extent you can put more US steps and more US people or more designated country steps, designated country people in that process there, it can contribute to the substantiality of it, which is again, is substantial is a relative term, but those are questions that I think are always worth asking, because even if they're not the meat of the issue, they're definitely gravy around it, and that gravy can influence the flavor when you're trying to get the government to come along with you. And I'm not saying that we're trying to pull the wool over their eyes or run a con. I think we're trying to be honest and sincere here. But the more you say China, India, overseas, and the less you say United States or designated country, I think we just recognize that it's more likely that it's substantially transformed somewhere not approved versus somewhere that is approved. And so
Yeah.
I think that that's especially if you're a manufacturer, those are real questions to consider. And I counsel a lot of clients as they try to figure out, where do we set up manufacturing steps and how do we do this modularly? And frankly, a solution for Energizer may very well have been, maybe I source half my components from China. I source the other half from United States, including the LED, right?
Yeah.
And then I do some shaping and cutting on some of these things when they're in the United States. That could have probably gotten them over the hump there to say, oh, okay, now it's a substantial process. Yeah, now we can give you credit for that. But it's so a lot of times there is opportunity to fine tune that manufacturing line that companies will often take advantage of to make sure that they are compliant. And again, not that they're gaming the system, they are doing exactly what the system contemplated, which is to say encouraging US-based and trade agreement partner-based manufacturing.
Yeah. Yeah. And just curious, is there, do you know how that story ended? Do you know, did Energizer find did it have a happy ending for them? Were they able to source the LED and all this stuff, or did they just kind of shut down the project and say, we'll just, sell them outside of TAA?
I think they walked away. If they revisited it, I'm not sure that there's anything been published on it, but
Okay.
I think they just walked away from it.
Okay. Just curiosity there.
Yeah.
But yeah. So, okay. The second one.
So the second one, so like I said, the first one's a little scary, okay, because it requires that substantial actually means capital S substantial. But the second one is great news for US-based manufacturers. And this came out, gosh, I think it was just last year, 2021, out of the US Court of Appeals for the Federal Circuit. And it's called Acetris Health v. United States. And what this was Acetris Health was a pharmaceutical supplier, and they were selling pharmaceuticals to the Veterans Administration. And the VA contract said, your products need to be TAA compliant, right? Okay, that's what most of these things say. So they were selling a product where they would source the active ingredient from India. They would bring it into the United States. They would compound it, they would capsulize it, they would package it, and then they would sell it to the VA. They had previously sought guidance, and they had gotten a TAA decision from US Customs that said that does not work. That is not substantial transformation, because again, peeking through to the key aspect of it, I buy a medicine because of its active ingredient. I really don't care what the pill's shaped like. So to the extent the active ingredient started in India, it was not really changed here in the United States. The US Customs said, no, that's a product of India for purposes of the Trade Agreements Act. Okay, so Acetris Health said, but that's actually not exactly what the rules say. The rules and regulations say that a product needs to be wholly a product of a designated country or substantially transformed. So two-part test. I don't know that anything is wholly anything anymore unless it's a some kind of crop or produce. So they said, okay, look, we recognize that this is not substantially transformed or wholly a product of any of these designated countries. But there's a second part to the definition as to what qualifies when it's a US made product. And for a US made product to qualify under the TAA, it needs to be substantially transformed or manufactured in the United States. And Acetris Health said it doesn't say that it needs to be substantial or wholly manufactured in the United States. It actually omits that adverb. It just needs to be manufactured. So they said, look, we're doing some kind of a manufacturing. We will concede the fact that that active ingredient doesn't change. We'll stick with the customs decision that says this is India, but we submit to you that this raw, kind of powdery, whatever active ingredient it is, that's not what the government wants to buy. That's not what it's giving to its veterans. It wants the pills. It needs this compounded with whatever elements are in there. And that's a meaningful process that we are applying here in the United States. And we're going to call that manufacturing of these pills. and under the definition in FAR 25.003 as to what constitutes a US-made end product that needs to be substantially transformed. We're not arguing that it's substantially transformed, but we are saying that it was manufactured in the United States, which gives them in. And the Federal Circuit said, yeah, we agree with you on that. So the truth of the matter is substantial transformation, I think, is what we normally think about when we think about a TAA compliance, and because I think that's the dominant theme over the last 20, 30 years. But you also have this case from last year that reminds us that even if your product is not substantially transformed in the United States, if it's manufactured, which is generally considered a little bit of a lesser standard, if it's manufactured in the United States, like what Acetris was doing with these pills, it could still qualify under the Trade Agreements Act, even if it's not substantially transformed. So that gives, I think, a lot of hope and opportunity, frankly, for US-based manufacturers that maybe can't get in and change the chemical nature of these active ingredients, but they can do something meaningful to it beyond just mere assembly, beyond just packaging it to deliver it to the customer. So that was a great win, I think, for industry.
Okay, yeah. I'm honestly a little confused by that. What's to stop Energizer from going back to the flashlight thing, saying we manufactured this, and and sweep the substantially transformation argument off the table?
I think actually you're probably exactly right. And so the disconnect there is probably Energizer's 2016, the Acetris Health case is 2021. I think Energizer could probably revisit that and reframe it the same way that Acetris Health did. Okay. And instead of arguing substantial transformation, arguing manufacturing under that definition there, and they would probably be able to get by on that. Okay, interesting. Yeah. So it's not a matter of inner workings or anything like that. It's a matter of deciding which path you want to, the legal team wants to take. It could be. Now, let me be clear on this. That's only if it takes place in the U.S. If I send that out to Canada or Mexico, to a maquiladora or something like that, to do that compounding, it wouldn't have worked. It needed to, it needs, the U.S. is manufactured. Every other country is wholly manufactured. So it's a little definitional distinction in FAR Part 25 that Acetris Health, to their great credit, I think they're brilliant. They're magicians, they're prophets. But I think it's great as far as what they did to identify a real regulatory issue there in terms of how these terms are defined, and be able to take advantage to make sure that the purposes of the statute are accomplished, which is to say US-based manufacturing, right? That's exactly what the statute wants to accomplish. They're able to deliver a good product at a good price to the federal government that ultimately benefits veterans. And so I really view that only as a win-win situation there. And especially where it gives us more flexibility through the supply chain as industry, I just see that as a good decision here that accomplishes policy goals, meets the letter of the law, and just gets everybody to a happy place. Yeah. That's great. Good stuff. So I'm going to skip over topic 3. I think we went over TAA, room for creativity, risk. We covered that really, really well. And I also definitely want to make sure that we get into the last 2 topics because they're pretty juicy. Okay. So let's talk about the TAA and services. And of course, the next one is your brilliant recommendation to bring to shine the TAA light on software. So within the framework of services, how does TAA apply to them? Yeah, so services are actually fairly straightforward in theory. The FAR 25.4 specifically said, so important distinction. So BAA, Buy American Act, only applies to products, not services. Easy. Okay. TAA applies to both products and services. Okay. So products we've talked at length about, substantially transformed or manufactured in the U.S. Those are the standards. For services, the FAR says that services are determined, the country of origin for services are determined wherever the company performing the services is established. And that's kind of little mushy language there. If I'm British Aerospace, but I'm established in the US because I have an office in Florida, am I established there? I think that the simplest, easiest answer for this is if you're a US or a designated country company, meaning if you're incorporated there, you're probably going to be good. And so if I'm a US based company performing work overseas in Afghanistan or Iraq, I'm probably going to be okay. What if I'm a foreign company that's performing work in Afghanistan and Iraq out of my Florida office? I don't know, that might work. I think it's worth clarifying, certainly with your contracting officer, but the idea of establishment is not necessarily the same thing as incorporated. And so I think that there is maybe a little wiggle room in there where you might be able to say, I have offices, I have an establishment, and that's the entity that's performing the work. But look, if I'm a EU company and I have an office in Florida, but I'm performing everything out of Berlin, I think that's, well, sorry, wait, Germany's an approved country. So it's, yeah, anyway, let's say, I'm an Indian company. I have an office in Florida, but I'm performing everything out of New Delhi. I'm probably, that's not going to fly.
Okay. Okay. Yeah. So to dive into that a little bit more, let's say this Indian company has a subsidiary in the US out of Florida. They're there, they have their own, their corporation or LLC. And if they perform services in India, will that fly through TAA, or is that the exact scenario that you just said?
So I think it's a little bit different in that they've got a US so it depends on which company is performing. So the Indian-based entity that has a subsidiary, if the Indian-based entity is performing the service, it's probably not going to work. So my suggestion, and I've had actually this exact issue with India, my suggestion to the Indian-based parent is subcontract that work to your US subsidiary, have them perform, and it's TAA compliant. And they don't necessarily have to farm that out to competitors and whatnot, and they're still able to keep it a little bit close to in-house. And so that US-based subsidiary was able to perform that work with really no question as to whether or not the company performing the work was established in the United States.
Okay. And then is there any guidance on percentages? Let's say in that, going deeper into that, let's say the Indian parent company project managed and put in maybe 15% of the total cost was just the project management team, but the development team was in Florida, making up the 85% remaining. Is there a certain distribution? Is it 51-49, or is there 75-25? Where are there any scales that have to be followed, or is that kind of department by department? Or is that just kind of like do it and see what happens?
Yeah, so I think that so the answer to the question is there's no hard and fast guidance on that. I think oftentimes it steers to the idea of, well, who's invoicing, like who is managing the work. And of course, we all get into a moment here where we need to get a little needs based of like, well, I've subcontracted to my subcontractor who is now delivering, and he's managing the work of the prime, right? Look, we can torture ourselves and get into some of these things. But I think you could probably get to a legitimate place there in terms of how you structure the delivery to the customer. There is no hard and fast rule as far as percentages. There is certainly an element of if 99% is being performed by Indian entities and 1% by the US based subcontractor who then invoices for it. I think we all agree that maybe looks a little fishy.
Yeah.
I'm a big advocate, especially on services, since that word established can be a little fishy. Talk about this with your contracting officer, find out what he or she thinks about it and say, hey, look, this is our interpretation. And we just wanted to run this by you so that you're aware. And there you go. And if he or she has problems, work with them, right? If he or she doesn't have problems, then good. Even if somebody comes back later on and says, Gallagher, what you did was wrong, I've covered myself a little bit because I was trying to be open and honest and working my way through this with the government as opposed to trying to mislead and defraud. I'm a big proponent of disclosure with the government customer so we can work together. And I think that helps meet mission success. And I also think it helps reduce risk of later, being called out and being accused of fraud.
Yeah. That's what I generally tell folks that ask, work that out with the KO and get some guidance. It is hard. I understand the position of a vendor that is trying to pull together a proposal, and you have some pretty dramatically different labor costs, whether it's going to be sourced in India or sourced in Florida. So they kind of need to know going in. And then they also, that's a question to ask the KO that you don't want to get, you don't want to put off a bad impression as well. Cause if, but it is an important question to ask.
Yeah, and I'll tell you, look, my perspective on this is I go to the contracting officer. I say, I just want to do right by you. Like, help me get to solutions so that we don't have problems we have to deal with later on, right? Yeah. I mean, I'd rather work a little bit harder on a solution than have to deal with all the heartache and headache associated with, things exploding a little bit down the line there. And so I agree with you that having those conversations, they're sometimes a little bit, I don't know, shameful. They're a little embarrassing to have because we want to be the contractor who you hired me to do a job. I can do this job, but I think that it's important on some of these legal requirements that we be able to have these conversations, recognizing that I'm not trying to pull the wool over anybody's eyes. I just want to do right, and you're going to help me do right, and let's just get to mission success.
Yeah. All right. Well, that was great. Very clear. Now let's jump into software. How's TAA apply to software, which is kind of a product, kind of a service.
Yeah.
Kind of its own thing sometimes, the way it's priced, Yeah.
Yeah, it's so software is an interesting thing because you're right. It's often sold as the service or it's sold as a product. So, and frankly, the way you sell it to the government will, I think, affect as to how it is. If you sell SaaS, software as a service, SaaS, to the government, I submit to you that it's a service, and you kind of jump through those service hoops that we just that we just talked through. I know an awful lot of companies that have it's 100% based, Indian developed, Indian tested, Indian, right? All of these things, and they say, you know what, my go-to-market strategy is I have to sell this as a software as a service. And so they market it like that. They get it on contract as that. The CLIN line item specifically describes service so that I, as a US-based company, can sell that to the government. And boom, I think that gets you most of the way there where you're meeting the TAA requirements there, even though the software might otherwise feel like it's hypothetically stamped made in India. The truth of the matter is, if you're delivering it as a service, and if the company delivering that service is established in the United States, you're clean under the TAA. So, so I think that's one of the advantages of being able to do it. And I think companies, like I said, not necessarily that they're gaming the system, but sometimes you kind of have to know and understand what's your go-to-market strategy. What can I comply with, and what can I not comply with? So, so let me give you an example on that then. So, software as a product. This is where it gets a little hard. Like there's decisions going back, and there's only a few, frankly, from U.S. Customs, but where they look at country of origin of software. And unfortunately, most of these decisions, and I kid you not on this, people, but I'm sorry, it is what it is. Most of these decisions relating to country of origin relate to software vis-a-vis the CD-ROM deliverable. Okay. Now, I know 1994 called, it wants its AOL dial-up discs back, but these are really the world that this came out of. And so I've had some clients, when they sell the product, they actually will sell it to the government customer, and they will stamp it to a disc or to a read-only media, and they say, here you go, here's the delivery on that. Because the idea behind it is that the software is all foreign, they can't get any really US or designated country content in there. But there is case law going back to the 80s and 90s that says, like, when you stamp, when you press, when you burn that onto media, some of these read-only media, that's a substantial transformation of sorts of the product that you're delivering to the government customer. And so I've had conversations on that with, I haven't had them in the last couple of years, but in the 2010s, high technology companies, where they were like, how can we deliver this software to our government customer? And I had to tell them with a straight face, you burn it to a CD and deliver it to them. And they say, are you kidding? And I said, that'll get you there. And so it's an imperfect solution, but the reason being is, look, the TAA is a 1979 statute, and it lives in a manufacturing space. And so over the last 40 plus years that the TAA body of law has built out, it's people in the government consistently trying to squeeze it in and figure out how does this square peg that is software fit into the round hole that is manufacturing. And as we know, they don't fit exactly. And so they kind of assess, well, where is it built? Where is the like physical change happening to it? And some of these media cases, even though they feel so dumb today, they're still out there. They're still persuasive. And so that might be that might be a solution way to get it, where you're delivering it as a media, pressed, burned, whatever, onto read-only media in the US or a designated country. That might be able to get you over the way. The more modern way, though, the more modern way, frankly, is the direct delivery, right? You develop software, you've got it, you sell it to the government customer, they download it, they install it, they use it, and voila. There's very limited case law as far as what's going to constitute substantial transformation of this. And the cases, again, they really rely on a manufacturing type process. And so unsurprisingly, they say that it's the software build moment that they kind of point at as the crux, right? You could have 100% Indian made or Indian written source code that's written 100% by Indian engineers. And then once you bring that source code into the United States or a designated country and compile that into object code, that compilation process, that object code build, that's the process right there where it's equivalent to 100% Chinese parts being brought into the United States and being built, substantially transformed into something new and different. Now, so there's official case law on that, and I've written a blog article on that you can find at my blog, governmentcontractslawblog.com. There's not a whole lot on it. There's only about 2 or 3 decisions. The questions that I've had clients ask me is, well, what about later in the process? Okay, once I build that compile code and I do that in the United States on US-based servers, just to be safe, right? Like, then what are there other things? What if I do other things in India? Does that like corrupt this? And I don't have a perfect answer for that. I think that one thing that is clear is that the mere act of downloading it from a server, I download this off Josh Inc.'s server to install on my government laptop. That's not substantial transformation. That's merely a transfer. So there are other things that I have to do, that I can do between the build and the delivery process to the ultimate government customer, that I may be able to play with. Meaning, if the build happens in India, can I do other things later on? And the answer is maybe. But at the very least, we know that the build, the government has acknowledged that as a critical step. And if you're doing at least the build in the US or a designated country, everything pre-build won't matter. Okay,
Got it. Very interesting. So
you're the first person who said that. Just kidding.
No, it is. It's interesting that this, the TAA from the 70s is still kind of, running running the world here in this way. And there's just, you know, a lot of big brains going towards trying to mold it and basically apply it in a way and try to basically, yeah, I mean, software is basically alien technology from this, if you're looking at it from the 70s, you know,
Right.
There's nothing that they even considered that it would come like that. And it, yeah.
Yeah, well, I'll tell you, there have been some thinkers in industry and government, and I applaud them of saying, like, we need to look at software completely differently. Because, like, the classic model on this, right, is how do you build a car? And
Yeah.
the answer is I get my suspension, I get my wheels, I get my engine, my transmission, my frame, my shell, my seats, right? All those things, and I put them together and I get a car. But the problem is software doesn't work like that. And so there, I do agree with a lot of these forward thinkers who think, like, look, we just need to throw out the paradigm that software is something that you manufacture and just face the reality that software is something that is developed much more organically.
Yeah.
And maybe there's a completely new way of looking at that. I would love it if that happened, but unfortunately, institutional inertia, especially when it comes to government bureaucracies, is going to rule the day. So that inertia that started in 79, it runs through CD-ROM discs in the 80s and 90s.
Yeah.
That still has a little bit of power today, for better or for worse. And I hope somebody will come along that can be a Martin Luther and, you know, pound the theses on the door and say we need to look at this differently and start a different way of thinking. But I don't think we're there yet. And frankly, especially too, with all this talk from Trump and Biden about buy American this and buy American that, I don't think anybody really has the courage, the political courage in government to say, let's look at this a different way. Everything right now is trending toward being very close and being very cautious and supporting U.S. industry. And so.
Yeah. Yeah. Well, I mean, the funny thing is there is an argument to be made that Buy American Act is somewhat loose in a lot of ways as far as American, you know. So, I mean, I know it is dollar, you said it was more focused on dollar buildup, cost buildup than substantial transformation. But yeah, it's really interesting. It's yeah.
Yeah, it's, you know, it's, I guess this is one of my bottom lines on it. It's, you know, we can debate as to whether or not it's good policy or not. And I'm sure that any viewers here could probably do that as well and say, oh, I disagree on this and that. And again, my objective is not actually to say we need more of this or less of this. It's just the reality of, okay, let's find the world in which we live and how do we navigate our way through. For companies that have to sell to the government and you have to certify either expressly or impliedly that I'm delivering something that's compliant, how do I do that safely? How do I do that honestly? How do I manage my supply chain so my government customer gets exactly what I want? Yes, it's probably going to cost more because made in China is cheaper than made in the USA. Okay, so how do I kind of deal with those market pressures there where the government says it wants to pay more for domestic manufacturing, but the guys who own the budget really kind of don't, right? And so, so you get into a little bit of tension there. And I just, you know, in my job, and I hope one of the things we've accomplished here on this today is just to educate people a little bit more that regardless as to whatever the policy should be, it is what it is. So let's live with it and try to make sure that we can manage our administrative obligations, make sure that we're honest and truthful. I've said it 8 times. I mean it 8 times. I want to make sure that everybody is, we do our best to make sure that we're honest and truthful to the federal government and that the government gets exactly what they need and exactly what they want, even if it is at a little bit of a premium price, which it's going to be if it's from one of these 120 plus countries, including the United States. And so I think once we can kind of make peace with that and make sure that we understand what's the administrative path through, then I think we can kind of get back to business of accomplishing mission objectives, making sure that I'm doing the right thing and making sure that the government's getting exactly what it needs. Yeah,
absolutely. Well, thanks for talking to me. And I learned a ton. Do you have any kind of final thoughts, advice, anything that is worth saying that wasn't covered?
No, I think I've covered it. I mean, I wish people the best. Look, if people have questions, feel free to reach out to me. You can, I mentioned my blog, governmentcontractslawblog.com. You can go in there and search for TAA, and I've got a lot of stuff on there. And frankly, a lot of other things as well. If you want to read the musings of a madman, but there's a lot of stuff there from my partners, and we try to have a very practical business type perspective on this. So that's one source. You can reach out to me. I'm on LinkedIn. I'm on SheppardMullin.com. You could go and get my email address. I'm happy to talk and even entertain hypotheticals about a friend of yours. Oftentimes people say, I've got a friend who has a problem, and let's talk about your friends. If it's a big problem, we could talk about an engagement and see what I could do to help. But I think a lot of times, a lot of this, we can, to the extent we can educate each other, we can find a way through. There's not always perfect solutions, but I do believe that there are workable solutions. And that's I think at the end of the day, you can't ask for a lot more than that.
Awesome. Well, thanks so much. This has been great, and yeah, we'll close it out here.